for the plenary session 2, followed by questions and answers by Professor Michael Thompson from Leeds University, United Kingdom, and moderated by Ibu Wardah Yuspin, PhD. Okay, time is yours.
Baik. Assalamualaikum warahmatullahi wabarakatuh. Masih semangat ya? Harus habis makan ya, jadi harus semangat. Tapi jangan ngantuk karena siang-siang ya. Bagi yang ada di belakang, saya mohon yang depan diisi terlebih dahulu ya. Jadi biar penuh tempatnya, gitu, nggak terlihat sangat kosong. Silahkan yang masih di belakang, yang masih berada di luar, saya harapkan untuk segera masuk sehingga bisa segera dimulai waktunya. Baik. The honorable person, Professor Michael Thompson. First of all, let us thanks to the Almighty Allah Subhanahu wa Ta'ala. Because of His blessing, we are able to come here to join in this international conference. Secondly, salawat and salam also delivered to our Prophet Muhammad Sallallahu Alaihi Wasallam, who has guided us from the darkness into the brightness. Ladies and gentlemen, the presentation today, presented by Professor Michael Thompson, is about a capabilities approach to advancing children's rights. Let me introduce Professor Michael Thompson first. Professor Michael Thompson graduated from University of Southampton and then the PhD program in University of Birmingham. He also have held visiting position at the University of Sydney and Emory University, Cornell and Emory University. He also wrote several journals, mostly about health law. The title is Medicine and Abortion Law. Also realizing social justice in public health law, abortion law and professional boundaries, also many other journals. And also he wrote several books like Exploring Masculinity's Feminist Legal Theory Reflections, Endowment Regulating the Male Sex Body, Reproducing Narrative Gender, Reproductive and Law. Yeah, it's quite a lot of books and also journal. Well, ladies and gentlemen, the presentation today, it will be takes like 30 minutes. Okay, is that okay? 30 minutes. Yeah, more or less 30 minutes, and then another 30 minutes for question and answer. Okay, Professor Michael Thompson, the time is yours.
Okay, thank you very much, and good afternoon, everyone. I hope everyone's had a very good lunch. I'm really delighted. This is my first visit to Indonesia, and I'm delighted to be here. And I'm particularly delighted to be in Solo, which has such a good reputation for its child-friendly policies. And of course, it's a great honor to be speaking at this conference on child-friendly education and well-being. And thank you, Wardo, for your hospitality, especially yesterday, and your kind introduction now. Just to give a little bit of an introduction to me before I go on to talk about children's rights and the capabilities approach. As you probably know from the other slide, I'm a professor of health law, and I work primarily at the University of Leeds in the north of England, but I also am a professor at the University of Technology in Sydney. I'm also in Leeds. We're a faculty of 70 people, and I'm director of research in that school. And I've also set up, and I'm a director of the Centre for Law and Social Justice. So we are 20 academics and 20 PhD students, covering a range of areas where the idea is that we want to promote greater social justice through the use of law. We're very interested. We have a number of experts in the field of disability law in particular, and so if you are looking to move on, if you're looking to do scholarship in that area in the UK, we're a very good place to consider. Most of my work sort of works around or coalesces around health, but how that intersects with women's health and how that intersects with children's health. And in both my work at Leeds and my work at the University of Technology, Sydney, I support work in the area of health justice. So the idea there is that all of the rights we might think about, the right to education, the right to family, the right to life, the right to association, all really require a good level of health for us to enjoy those fully. But we also know that you need all these other rights in order to have good health. We know that in equal societies, people are generally healthier. We know, of course, that in Scandinavia, we have some of the best health levels and we have some of the most equal societies. We also know that you need education and that you need good housing, you need good support, good nutrition in order to be healthy and to have long lives. I live near Birmingham, in the middle of the United Kingdom, and we know that the age difference between the poorest and the wealthiest communities, there's 10 years difference in their average life expectancy. So differences in income, differences in opportunity have a very direct effect on health. So we have a concept of health justice. In the talks in the very good and enlightening talks that we've had so far this morning, the concept of best interests, or the phrase best interests, has been raised a number of times. And we know that this, in law and in policy, it's an accepted standard. And whenever we make a decision about children, about their upbringing, about their welfare, the best interests of that child should be our paramount or our primary consideration. However, at the same time, what we might mean by best interests is given very little formal shape or content. Okay, so we have lots of policies, we have lots of legal provisions that say the child's best interest should be the most important thing in any decision making. But we very rarely have an idea of what that means in practice. In law, which is where, of course, I'm coming from, this has been the subject of sustained criticism. So we have academics, we have practitioners, we have members of the judiciary saying we're told to make decisions in the best interest, but we're not told what this actually means. So I've been working on a project for the last 2 years to try and not abandon best interests, because of course we should be doing this. We should be acting in the best interests of children. But a project which aims to give this notion some shape, to give it content, to give it some guidelines. So that's the project that I want to share with you today as I begin to finish it. So the capabilities approach proposed by Amartya Sen, the very famous Indian philosopher and economist, and others such as Martha Nussbaum, a famous American legal philosopher, provides a very theoretically nuanced and empirically supported framework for evaluation, development, and the development of policy. We can describe it as defined as an approach to comparative quality of life assessments and to a theory about basic social justice. And that's the sort of point I want to convey to you, is that this is a very good theoretical framework that has a lot of empirical work behind it that gives us an idea about how we might reason about policy and social justice. So the health theorist Sridhar Venkatapuram summarizes the health theorist Sridhar Venkatapuram summarizes the capabilities approach in the following way. He writes that capability theorists champion the central idea that the well-being of individuals is best reflected in and promoted through their capabilities to be and do. Okay, this is it sounds like a very simple proposition, and it is a simple proposition. We should measure people's freedom, we should measure best social justice in a country by assessing the freedom that people have to be who they want to be and do what they want to do. So we should be able to look at men and women, children and adults, and say, what choices and freedoms do you have? If you're an adult, do you have freedom to be an academic, to be a painter, to be an artist, to be a parent, to be religious, to go into a monastery, to go into the church? Do you have freedoms to do nothing? Do you have freedoms to raise your children? Do you have freedoms to cycle in the street? Do you have freedoms to drive cars? Do you have all of these freedoms? Can you be who you want to be in terms of your professions? And this should be really what we look at when we assess freedoms. So what I want to do is convince you this afternoon, that this is a framework that you might take away to use in your work, but also to show precisely how this might be used in legal contexts and in the context of social work and in terms of doctors when we're making best interest assessment on behalf of children. Okay? So I want to do those two things, to give you this if you haven't heard of the capabilities approach, but then also to give you an example of how I'm using it in my work. So what I'm going to do is start off by just giving an introduction to the best interest standard that people have talked about this morning. I'm then going to give you some criticism, and there's a lot of criticism, so I'm just going to narrow it down to a particular line of criticism. Then I'll introduce to you the capabilities approach, and I'm going to use education as an example to try and give us a little bit more flavour of the richness of this approach. And then I'm going to justify it briefly in terms of its theoretical underpinnings, and then I'm going to give you an example how we can practically use it, how it's practically been used in the United Kingdom, although I think it has relevance everywhere in the world, including all of the destinations you've arrived here from today. But I'm going to start with a story. I know that one of our most famous English authors, a contemporary English author, is Ian McEwan, and he's been translated into 30 languages around the world. He's one of our most influential writers. And in 2014, he wrote a novel called The Children's Act, which is about our primary legislation in the United Kingdom. And it's about to become a film, just in case you see it here in Malaysia, in Indonesia, sorry. So, in his novel, The Children's Act, Ian McEwan details the overlapping professional and private lives of the High Court Judge Fiona May. She works in the family division, and in the initial pages of this novel, we see Fiona May carefully construct her judgment in the case of two children who are the products of a divorce, a separation. And the judge has to make the decision about where the children will be schooled. And of course, in making this decision, Fiona May has to consider the child's best interest, these two girls' best interests. The father, from an orthodox religion, wants the girls educated in a school where they'll be separated from boys, but also they'll be separated from people who are not from that sect. Okay, so it's a very segregated form of schooling, and also the girls' schooling doesn't extend into higher level education because the girls aren't seen as destined to professions. They're seen as destined to be wives and mothers, and that is their duty in life. So they're not given that there isn't that professional expectation for that. So the mother already, against the father's objections, has moved them to a religious school, but a religious school which is co-educational. So they can follow their faith, but they follow their faith in a mixed education where there's a full level to the highest level of schooling. So Fiona May writes, on the surface, the dispute concerns Rachel and Nora's schooling. However, at stake is the entire context of the girls growing up. It's a fight for their souls. Whilst I'm not sure it's a fight for their souls, it surely is a fight for what happens to the girls and what shapes the rest of their lives, the opportunities or freedoms that those girls will have. And Ian McEwan provides significant detail of Fiona May's practice, how she thinks and how she'll write her judgment. And in considering, this is a bit of a long quote, sorry, in considering the best interest, he writes, Fiona devoted several hundred words to the definition of welfare, and then a consideration of the standards to which such welfare might be held. She followed Lord Hailsham in allowing the term to be inseparable from well-being and to include all that was relevant to a child's development as a person. She would take the widest possible view. Welfare, happiness, well-being must embrace the philosophical concepts of the good life. She listed some relevant ingredients, goals towards which a child might grow: economic and moral freedom, virtue, compassion and altruism, satisfying work through engagement with demanding tasks, a flourishing network of personal relationships, earning the esteem of others, pursuing larger meanings to one's existence, and having at the centre of one's life one or a small number of significant relations defined above all by love. And this is, of course, what we would want for children. We want all these things. We want them to have a fulfilling life and all of the opportunities that she importantly sets out. And McEwen is right in that the courts consider this. And what I want to do is I just want to keep hold of this very vague idea that we have of the good life and see how the court responds to it. And I also want to keep hold of the case of Nora and Rachel. So I'll return to Nora and Rachel and the question of education later and how we might look at this in terms of best interests. But to start, it's worth saying that Fiona May is engaging with our primary piece of child legislation in the UK, which is the Children's Act in 1989. And this sets out that in any deliberation about the welfare, Rachel and Nora's best interests must be the paramount consideration. And this is a long tradition in English law. We can go back to the 19th century to see similar directions. If we look at the actual wording of the Act, we see that Section 1.1 says that when a court determines any question with respect to, firstly, the upbringing of a child or the administration of a child's property, any income arising from that, the welfare of the child must be the court's paramount consideration. And also we know that in 1989 we had the United Nations Convention on the Rights of the Child, which again has been mentioned several times this morning. And of course we have a team working that was launched today on monitoring and supporting work in this area. And we know that there in Section 3.1 we have a similar provision, although the wording is slightly different. In all actions concerning children, the best interests of the child shall be a primary consideration. And English courts have said welfare, best interests, primary, paramount, these all mean the same thing. What we need to do is we need to promote the best interests of children when we make these decisions. So, as I've already said, the best interests of the child as a test has been the focus for wide-ranging criticism. And this criticism is compelling. It's been argued that the standard lacks any content. We don't know how to realise best interests. It's vague because it doesn't have any content. It can also be seen, because it doesn't have content, we can see that it advances maybe parental interests. So we can see that judges at times advance parents' interests rather than advancing what might be in the child's best interests. In my own area of health, we can also see that at times it advances the doctor's best interests, what the doctor thinks, rather than what might be in the best interests of the child. Also, we can see that because it's very vague, judges can at times make prejudicial decisions that rely on their understanding of what is good for a child. And these can be, most of our judges in the UK are in their 60s and 70s. They're white, they're middle class, they come from a very particular background, they have very particular understandings of the world and of children. And that can mean that we have quite dated understandings of how children live and how they might flourish. What I want to do is not to cover all of that, but just to focus on the question of values. And here I want to look at the fact that what happens when we have no values, when we just have this vague statement, best interest, but we don't have any values underpinning that. Then I want to look at the fact that sometimes we have the wrong values. And then finally, I want to look briefly at the question of values and evidence. And that's my sort of jumping off point, because I want to say the capabilities approach can give us an evidence base about what is in the best interests of children. So in terms of no values, Lord Justice Mumby, who is currently our president of the Family Division, so he's one of the country's most senior judges. He's an extraordinary thinker, an extraordinary judge, and he was writing outside of court, and he wrote, "What exactly is meant by best interests is neither self-evident nor altogether clear. There are two reasons for this uncertainty. First, the question has been given surprisingly little consideration by the courts. Secondly, and notwithstanding strong criticism, the courts have traditionally failed and even on occasion refused to articulate any principles or values to be applied in operating the best interest test." So this failure to articulate principles or values has generated criticism regarding what might, if anything, fill this vacuum. So, for example, it has been contended that the failure to provide any content means that we give decision-making away to experts. And in some ways that's good. We want experts to provide information. We want educationalists, we want medics, we want psychologists, we want social workers to provide evidence. But we don't want to give it all away to them. We want people to bring it together and judge it against a set of values and a system of evidence. So, the question of wrong values. So the welfare principle works on individualized assessments and predictions. So each child is treated individually when they come into the court or when social workers are considering their situation. And courts have been at pains to say that they treat each child individually. They treat each child as a person. But it's not a great leap of imagination to see that at times particular values can filter into this. Particular understandings of how we should live or how we shouldn't live can factor in to judicial decision-making. So in this test, it's been criticised as also being too subjective. It's too much up to the judge to make the judge's own decision. And if we have judges who may have prejudices about how different families are constructed, what the parental makeup is like, what the family shape is, we can see this impacting on how decisions are made for individual children. And so Helen Rees, a very well-respected family lawyer, has written that the indeterminacy of the children's welfare has allowed other principles and policies to exert an influence from behind the smokescreen of the paramountcy principle. Okay, so she's saying the best interest test provides the smokescreen. We say we're acting in the best interests of children, but actually because there isn't a checklist or a clear idea of what best interest means, we can bring in other values, the wrong values, into this. So I want to move on now to look at the question of values and evidence. So taking a quite different tack. Jonathan Herring and Charles Foster. And Jonathan Herring is an Oxford professor who's extremely well known in the areas of family law, health law, and also criminal law. He's a very senior and respected academic. Excuse me. They've observed that behind judicial determinations of best interest, there lies an essentially Aristotelian notion of the good life. And we saw that at the beginning. We saw that with Fiona May, talking about the good life, talking about flourishing, talking about friendship, talking about meaningful life. And this would be sort of Aristotle's notion of the good life. And we can always go back to the ancient Greeks for something very useful and helpful. And Herring and Foster go on to state that it is a routine part of judicial business to take a view about what human beings quintessentially are and how they best live. And judicial statements at times support the author's contentions. However, even though Herring and Foster go so far as to say that a judge's job in determining best interests can be accurately described as maximizing the flourishing of humans, and that they should facilitate human thriving, they nevertheless say that we shouldn't have a philosophically explicit or grounded protocol. So they write, in the vast majority of cases, there is little dispute over what is in a person's best interests. In the truly difficult cases, it's unlikely that a more detailed list of factors would create any more predictability than the straightforward best interest test. Further, a philosophically explicit protocol would quickly become tyrannous. Okay, and this is my pivot point. This is the sort of key switch in my presentation to you today. I think they're right, to some extent. I think we do want, we do act in the best interest of children in court. We do want a notion of the good life. We do want to support thriving and flourishing. And in a lot of cases, we know what the outcome is. In a lot of cases, we do know what the clear answer is. But in other cases, we don't. But also, even in the clear cases, we should have an evidence base about that decision. We should be able to explain to parents why we think this is the case. We should also be able to share that knowledge outside of the court about what a good life what might constitute a good life, what we might want to consider. So I think we should perhaps dare to be tyrannous. I think we should look at what frameworks we can import to help us in our decision making. So nearly 40 years ago, in a lecture entitled Equality of What, Amartya Sen started to develop the capabilities approach. And of course, equality of what is one of those famous philosophical questions. If we want a more equal society, what should we focus on? Should we focus on resources? Should we focus on services? Should we focus on freedom? And so in his article, Equality of What, he said we should focus on the capabilities that people have. So, the approach provides the theoretical foundations for what is an alternative understanding of human flourishing and development. If we look at Martha Nussbaum, one of the other key architects, she writes very helpfully that the key question to ask when comparing societies or assessing them for basic decency or justice is what is each person able to do and to be? Okay, so that question at the beginning that I asked you to keep hold of, this simple notion that what is most important in a society is what we can be and do. What do we have the freedom or the ability to be or to do? Can we go out? Can we take part in discussion in the public arena? Can we be politically engaged? Do we have all of the capabilities or freedoms to act as capable citizens, to act as citizens of change, as we heard about earlier? And very interestingly, a lot of work done in education talks about capable agents. Okay, so it talks about empowering children in order to go out and act as change agents, to change their society, to redistribute the resources and make society better and more equal. So there's a lot of overlaps with what we've heard about earlier today. So the Human Development Agenda, as developed by Sen and Nussbaum, provides a reorientation, and it's a very important reorientation towards the individual in society. And it's a movement away from what we normally see in international civil society, from idea of aggregated measurements. So we know of gross domestic product, we know gross domestic income, and we make judgments based on how much a country generates, how much a country has, what an average income in a country is. But we very rarely look at the fact that that income doesn't sit evenly, that product isn't shared evenly. When I was flying here on a very long flight from the United Kingdom earlier in the week, I flew over a large number of oil-rich states. I flew over states where we would look at the gross domestic product and the gross domestic income, and they would be high. But we also know in those countries that the income distribution is extraordinary. We have extraordinarily wealthy people, and we have a large number of people who are at subsistence level, who are struggling to feed themselves. We also know that in very rich families, we know that the women have in some of those nations, not all of them, but in some of those nations, we know that the women have very restricted opportunities. In some nations, they cannot drive, they cannot become educators. In a lot of circumstances, they cannot have freedoms to choose their profession. In some places, they cannot walk in the street without guardians. So they might be very wealthy, but they do not have freedoms or opportunities or capabilities. And I think a very important thing about the capabilities approach is it's very, very attentive to questions of gender and gender equality. So what we have here with Sen, he says that it's a change. He describes it as a serious departure from concentrating just on the means of living, so just on income, to the actual opportunities of living itself. Okay, so this, again, it's quite a simple idea. Rather than looking at resources alone, resources are important, but rather than looking at resources alone, we have to look then, not just at that, but what are the freedoms that we give to women, the freedoms we give to children, the freedoms we give to people from different castes and backgrounds and races and nations, if they come into our countries, what freedoms and opportunities do we give these people? And that is that helps us to judge more effectively questions of social justice. So, that gives us some idea of the background. The important thing for me, and I think it's the important thing for many of you as educationalists, as people involved in policy, is that the capability approach provides an extraordinarily good link between theory and practice. And Heather Widdows, who's an ethicist, and Ian Law, who's a philosopher, have written that the capabilities approach captures much of the best theoretical and conceptual work, while also being applicable to real-life cases and actual practice. And much of the practical applicability of the approach derives from the significant interdisciplinary work that's been done to operationalize the approach. And this comes in the form of capability lists. Amartya Sen has always opposed having a final list of capabilities. He's described this as a grand mausoleum. Okay, he doesn't want this dead, static list. He wants the capabilities approach to go into different countries, to go into different contexts. So he wants it to go into the United Kingdom and to be looked at in cases of equality, or to look at in education. And then we discuss what is most important, what freedoms or opportunities are most important in these nations, for these people in this context. Martha Nussbaum has provided a list of what she sees as a list of universal capabilities, and it's very, very interesting, and it's based on a lot of research, and it's one thing. Sen provides a different model, and it's very interesting to look at where they overlap and where they differ. Anyway, discussion of list takes me a little bit further than I want to go at the moment, and what I want to do is just very quickly look a little bit more at the theory. So children, this theory has been around for 40 years nearly, and in the initial literature, in the foundational or the canonical literature in this area, children didn't really figure. However, more recently, Martha Nussbaum and Rosalind Dixon, an American lawyer, have published an important piece which puts children at the heart of the theory. Sorry, it's quite a lot to read from the back. So they say, the starting point for the capabilities approach is the fact that human beings come into the world with a variety of incomplete capacities that need development. The capabilities approach argues that these nascent or beginning abilities exert a moral claim that they should be developed. Without that development, they are fruitless, cut off, only a shadow of what they might be. This idea of waste and tragedy is at the heart of the political imperatives generated by the capabilities approach. The theory is thus, in its very nature, intensely focused on early childhood, as a time when critical forms of support for development are either present or absent. And I think that's a wonderful explanation of what the approach aims to do, what the moral imperatives are behind it, what the moral impulses are behind this, but then also what the political obligations are. So here we see the difference between maybe moral obligations, ethical obligations, and then what we might demand of our political leaders. And given that we're at a conference with very many educationalists, I just want to talk about this a little bit more in the context of education. And here I want to return us to my story, my novel, Ian McEwan's The Children's Act. And I want to return us to Rachel and Nora. And allow us to discuss a little bit more what the capability to be knowledgeable is really about. But first, another quote from Dixon and Martha Nussbaum. So Adam Smith is a famous 19th century Scottish philosopher. And Adam Smith, this is them saying, Adam Smith, observing the children in Scotland, and this is the 19th century, this is the 1820s, observing that children in Scotland were sent to publicly provided schools, while children in Scotland went straight to the factory, says that the human capacities of the English children are mutilated and deformed by that treatment. This is in fact the core moral intuition that guides the capabilities approach. And I think for many people that is why we go into education. We go into education because of that commitment to supporting and developing the capabilities of the children and the young adults who work with us. So Fiona May finds for the mother. Fiona May finds that it's in the best interests of Nora and Rachel to stay in the co-educational religious school that she's been sent to. And her reasoning reflects on the place of women within that religion, noting that this fell outside the mainstream parental practice and generally held view that children should be encouraged in their aspirations. Further, she suggested that the father should ask himself why he would deny his daughters the opportunity of a profession. If we look at Martha Nussbaum foregrounds the fact that each person in the capabilities approach is treated as an end, that the focus is on choice and freedom and concerned with entrenched social injustice and inequality, especially capabilities failures that are the result of discrimination and marginalization. And in some ways we can see that the father in this instance is arguably marginalizing his children and their abilities by not giving them the full choices that a full education enables. However, I think there's more to this than we maybe see with Fiona May. And we know that Sen and Nussbaum both recognize the intrinsic, the child-based importance, but also the society-based importance of education. For Sen, he argues that education can foster public debate and dialogue about social and political arrangements and can enable individuals to take part in decision-making processes at multiple levels, so domestically and nationally. And that it can empower marginalized groups to gain access to power and argue for redistribution. So they can be agents of change, or capable agents. They can change our societies. Nussbaum talks more generally about children, and she writes that education can provide critical thinking. We can reflect on our own processes of thought. We can engage with other people's processes of thought. What are the flaws in the argumentation? There's also, it encourages our cosmopolitan imagination. Why do others think like they think? Where are their thoughts coming from? How are their moral systems different? And it can also improve our narrative imagination. It improves our empathy. When new people come into our community, we can empathize with their life situations that are very different from our life situations. We can be more harmonious and giving in the way that we address each other. What I want to do then is to jump ahead a little bit and move to my practical justifications, which in a conference that engages people across different disciplines, where we are all interested in making a difference and maybe changing policy, I think this is very helpful. The law is a bureaucracy. We know it's a massive bureaucracy and it enjoys lists. It likes checklists. But it's not the only place. We know that doctors use checklists. We know that engineers use checklists. If we flew here, we know that the pilots have a checklist when they take off. Checklists seem to run the world, but there's an importance behind checklists. It's not just about bureaucracy. We've seen recently the President of the United States decide that he doesn't need frameworks and checklists. He can decide what he wants to do on his own basis. And we can see the damage that happens then. So as I've said, Amartya Sen ignores the idea. Amartya Sen shuns the idea. He really doesn't like the idea of a fixed set. What we need to do is to go out and ask people. We need to look at capabilities lists in each situation that confronts us. And capabilities are about agency. So it's about the agency of the individual. And that's meant in two ways. It's the agency of the individual to have freedoms and choices. Okay, what do you want to be and do? But it's also about agency in terms of constructing what is important to us. As educators, we should have an input into what capabilities are important for children. So it's a system which respects agency and promotes agency, but it's also developed through our agency and our conversations, public reasoning. So what I want to do is to give an example from the UK about how we've used this. And I'm using law because I'm a lawyer. I'm using the UK because I'm from the UK. But this has been done internationally in many different countries and many different circumstances. But I think it's helpful to use something from my knowledge in this audience. In 2006, we enacted the Equality Act. And this was an attempt to bring together a lot of different pieces of legislation. So legislation on discrimination, on racial discrimination, gender discrimination, and it created a duty of equality on public sector organizations, a very, very important development for us. It also set up the Equality and Human Rights Commission. And the Equality and Human Rights Commission were charged with developing an equality measurement framework. Okay, so they had to set up a framework that would allow us to look at 21st century Britain and judge how equal we are. Where were we falling down? With what groups of people were we not treating with the same equality? Were we denying them freedoms and opportunities? So the Equality and Human Rights Commission worked with our Government Equalities Office, with the Scottish Government, with the Welsh Assembly, and with the Office of National Statistics and others to develop a comprehensive measurement framework. And they started with Amartya Sen. So there's three building blocks to this. They started with the idea that freedom and equality is about what we are able to be and do. So that was the theoretical underpinning. They then moved on to look at international human rights obligations, and they brought the two together and said, if we look at these important statements of what our human rights are, what can we translate into freedoms, what promotes freedoms to be and do? And then following from that, they then took a list that they generated and they consulted with people. So just to work through that quite quickly with you. So, what they did in this first situation was to work back. This is two of the academics from the London School of Economics who led on this project. They said, working backwards from the actual standards recognized in core international human rights, so for example the United Nations Convention on Social and Economic Rights, to a set of underlying states of being and doing. So what did these core human rights protect in terms of our beings and doings? They looked at what was set out in international law through this. They then took the list that they generated and they consulted with 200 members of the public in 2 full-day workshops. And then they had a series of interviews and focus groups with people from different groups who are discriminated against in the United Kingdom. And they developed this list. Okay. So this is the capability list that is the basis for this framework. So I'll just pick out, they're all important, but I'll just pick out a few. So of course, we need the capability to be alive. We need physical security. Are you free from violence in the street? Are you free from violence in your home? Are you free from violence from the medical profession? Unwarranted treatment, unconsensual treatment, things like this. Do you have the capability to be knowledgeable? Do you have the freedom to be educated? Do you have a comfortable standard of living with independence? Can you have productive and valued activities? So do you have the freedom to be in any area of employment you might want to be? You're not restricted because of your colour or your gender. Do you have freedom to enjoy your family and your social life? Are you engaged in decision making? Do you have a political voice? Do you have the vote? And are you protected and treated fairly by the law? Okay. So this is a bit too broad brush. Okay, these are really big statements. So in the consultation with 200 members of the British public, in the conversation, they then looked at what people thought about each of these, and they developed more fine, detailed statements. And because I'm a lawyer, I'm just going to look at the last of these, okay? I'm just going to look at this important capability to know you will be protected and treated fairly by the law. And you can't read that, I'm afraid. That's very small, isn't it? So I'll just try and pick out again some of the most important ones from this. So in terms of the importance of law, we want to know that we're going to be treated equally and we're not going to be discriminated against. We want to be free from arbitrary arrest. We want to be free from arrest on the basis of our political beliefs. We want fair conditions of a trial. We want fair conditions of detention. We want affordable and high-quality information and advocacy. We need to be represented in court for this to be done fairly. We want to be able to own property, and we want to have our privacy respected. The United Nations Convention on the Rights of the Child in Article 12 says that every child should be engaged in decision-making about them, and children should help to develop policies and processes that have to do with them. It's very interesting that in the development of the United Nations Convention on the Rights of the Child, no children were involved in the proposals. I think there's one provision where children were asked. But it says that children should. And also in our Children's Act in the UK, there's an expectation that when children reach maturity, or maturity sufficient for the information that they're having to process, that becomes very important for us. Children get to determine the future. In this instance, the Equality and Human Rights Commission consulted with children. So they consulted with children who were between 13 and 16. Then they had a different group, children between 11 and 13. And then they spoke to parents of children under 8. And then they did a final set of consultation with non-governmental organizations, public sector organizations who work with children. And again, I'm terribly sorry, this is going to be very, very small. And I've lost the picture. I don't know whether someone's able to put the picture back up. This is my final slide and I've lost you. Okay, hopefully it'll come back up. So, here we are, phew. So, without reading through it all again, what is important is that children, when they were consulted, children when they were asked about what freedoms and opportunities were important to them, what was important with the law, they had specific things that were relevant to them that they wanted to add. So they wanted to see that detention was a last resort, Children should never go to prison unless there's anything else we can do, whether that means supporting them in the home, moving them to a different home where maybe they will be supported better, but they should only ever go to prison as the very, very last resort. They also said that they wanted protection by a minimum age of criminal responsibility. Until the 1980s, it was 14 or 16 in the United Kingdom. Since the mid-80s, we have an age of criminal responsibility of 10, which I think for a country that prides itself on its human rights is a national disgrace. We should be appalled by that. They also said that they should have access to high-quality information and mechanisms, for complaints and advocacy, where it's specifically designed for children. Okay? Information is very important. We all know information is power, but it should be written and constructed in a way that children can understand it. That means changing the language. That can mean using pictures. That can mean repetition. That can mean having someone to translate it in language that is appropriate for children of that age. We have to make the effort to do this. And also they said that in terms of property, that people who are 16 and 17, who are young adults, who can do many things in the country, should have the right to certain levels of certain financial products and protection. So, this is a framework for measuring equality in the United Kingdom in the 21st century. What I would argue is that we can use this for different purposes. We can use particularly the initial list, when judges and social workers and doctors are making decisions about what is in the best interests of children. And we can have an evidence base. All of this is based on not just theory, it's based on going out and looking at empirical work in all sorts of disciplines about what allows children to thrive, what allows them to flourish, what allows them to reach adulthood with as many choices and opportunities as is possible for them. And importantly, children have taken part in developing this framework. And I'll finish there with you. Thank you.
Okay. Thank you, Professor Thompson. Well, ladies and gentlemen, now we are coming into the question and answer session. I will divide it into two sessions. First session, I will open 3 questions, and before you mention your question, mention your name and also where are you from. Okay? Is there any question? 3 questions for this session. First one, second, and then, yeah, the man in the back. Okay. Mbak, tolong mic-nya dibantu untuk diberikan.
Good afternoon, Prof. Thompson. It was so nice and great presentation related the children's rights of education and law. I'm in the Aprilia. You can call me April or Aprilia. Now I'm the student of Magister Program of English Education Department, and I'm also the teacher in International Islamic School in Solo. Well, I pay much attention of some slides. For instance, the children's right of the ability to have physical security, to be healthy, to have knowledgeable, to enjoy the comfortable and etc. And nowadays there are some countries that out there happened the war. For instance, just like Palestine, Yemen, Afghanistan, and the other country. My question is, what kind of the effort or project of the researcher itself to meet the children's need related to their education? Or maybe you may show us the results of some researchers related this case or this problem.
Sorry, the microphone is quite unclear. I didn't quite hear the question.
Oh, okay. Okay.
Just the end bit of the question, sorry.
Oh yeah, okay. I'm Aprilia. You may call me April. I pay much attention of some slides in your presentation. For instance, the children's rights related to the ability to have knowledgeable, then to enjoy the comfortable, to live, to get healthiness, and etc. And nowadays, there are some wars in some countries. For instance, Palestine, Yemen, Afghanistan, and other countries. My question is, what kind of the project or effort from the researcher itself or from the experts in the world to meet the students' need there? Or maybe you may show us, please, the result of the research related to this case or this problem. Yes. Thank you, Professor Thompson.
Okay.
Yeah.
Thank you.
Second question over there. Paling depan Mbak, pojok sebelah sini. The one with the blue hijab.
Thank you for the moment. My name is Wahyudia Laksmi. I come from Universitas Muhammadiyah Jember. It was something new for me that understand still a lot of problem in your justice, especially for children. But I only have one question. From what you have delivered for us, I understand that the children that you mean is about 7 until 16. Yeah, is it correct? Yes. And what about younger children? Yes. And what I know is as early childhood. Yeah. What about them? What about your maybe your model? I think I will mention like that your model about the education in law or education in like maybe for the people for the community. Especially for the parents, maybe to make the early childhood understand about their right, especially when they have the problem like divorce and or maybe sexual abuse, as like that. What about your maybe your model that you can tell us for them? Okay, thank you, sir.
Bismillahirrahmanirrahim. Thank you, Mr. Professor Michael Thompson. My name is Nur Edi Prabha Susila Yahya. I'm from Yogyakarta. Pardon me, Professor Michael Thompson. I would like to ask about sensitive issues. in your opinion, what do you think, or what is your point of view when a child has involved LGBT, lesbian, gay, bisexual, and transgender? What do they, when the child then involve the LGBT and become one of them, do they have same rights like us? Thank you.
Okay, thank you very much for your questions. I should say at the start, before I answer all of the questions, that I'm very aware that I'm standing here speaking as someone from the United Kingdom, relying on theories that have been developed primarily in the West, and I'm coming to your country and talking to you. One of the things that I think is very interesting and important about part of my message is that the capabilities approach as developed by SEN is about adaptability, it's about local context, it's about people looking at what is important to their communities in the situations that they're considering. But I am also aware that I'm standing here in front of you coming from the economic north, which takes me directly to the first very, very difficult question. It's difficult and it's an important question. And the countries that you highlight, and particularly at the moment Yemen, where so many children are dying, and also where the United Kingdom is providing the weapons, to selling weapons to Saudi that are then being used against children in that country. I think that's, we have to be humble when we recognize that. However, the more constructive approach to this, the model that I spoke to you today draws on, or the model, not SEN's model, but the model that was used in the United Kingdom by the Equality and Human Rights Commission, draws on international human rights documents. So the primary documents that govern our human rights as a collective international community. If we look at the right to education and your question, I think for me, an important element of the economic and social and cultural rights is that these are progressive rights. Okay, there's two parts to my answer here. So these are progressive rights. We cannot expect states to all of a sudden reach the levels of education that the wealthiest countries reach. We have to provide time and support. So that's one set. The more important part of my answer today to you is that what we often forget is there's an obligation within these treaties for wealthy nations to support lower and middle income countries to realize these. So whilst we might be selling weapons to Saudi, we also have an obligation to provide other nations with the support they need to reach levels of education that are required within these international documentations. And so we do have the Swedish International Development Agency here. We have, the United Kingdom has its development agency, which is in conflict, of course, with another part of the government. So yes, I think that's, I think it's a very complicated and very, very, very important question. And I am aware of where I am standing and where I come from. But I also think it's very important for all nations to realize that this is about a cosmopolitan obligation. It's an obligation to all states. We don't just leave states to do this, particularly when we might have policies at government level, or we might have policies from international organizations which harm the development of education or the development of equality in different situations. Okay. Thank you for your question. Thank you. So, the issue around the capability to be knowledgeable that I was talking about today is all children. So it's not just teenagers, it is all children. And we know that children from a very young age can express their agency, I have a 7-year-old daughter who is almost 17 in terms of the way she talks, but from very young age, we know that children can express what they want, they can come forward with reasoned arguments, they can shape the way a family thinks and acts about opportunities and how it engages with the world. So I think this is relevant to the education at all levels. Okay. I've forgotten the second part of your question was about the law, and I've forgotten what it was. Can you remember? Apologies. Ah, yes. Yeah, sorry, very important second part of your question. I just wrote down law, which wasn't enough of a prompt for me. I think that's a really interesting and important question. So, Martha Nussbaum has developed, she's well worth reading. I think she's an excellent scholar. She's quite an amazing person. She's developed her 10 capabilities, which she sees as universal capabilities. And people have looked at that and they've taken it away and they've worked with it. And there's this very lovely example. There's a book by Jonathan Wolfe and Avner de Shalit, an Arabic scholar, called Disadvantage. And they took Martha Nussbaum's list of 10 and they went and talked to disadvantaged people, both in London and in Palestine and Israel, about what was important to them as disadvantaged people. And they looked at this list and they thought, yeah, they're all relevant, but then they added law, that for people who are disadvantaged, the law is very important, and to know the law. Okay, so to know your rights and to be able to have confidence in expressing yourself with your rights, with the law. And you will have noticed when the Equality and Human Rights Commission looked at it, they added as a fundamental capability law, the protection of the law. So we know that the law is incredibly important to individual people to protect their rights and for them to express, to protect themselves. And that has to be part of what we provide in education. That has to be part of what we provide in school. Children should have the knowledge of the protections that the law affords them. But on top of that, they should have a space where they can express that, knowing that they will be listened to, that they will be treated fairly, that they will be supported to talk openly, and that their privacy will be respected when they talk about the rights and what they want from the law. Okay, so I think it's a really important question, and I think it does really provide an idea of that the law isn't always something that just penalizes, isn't always something that prescribes. The law can be something that can protect and that can advance our social justice and our welfare. So thank you. The question about lesbian, gays, trans, bisexual, and other people. I'm trying to think my way into your question. I mean, human rights, these are based on human rights, and the capabilities approach both Martha Sen and Martha Nussbaum have described as a form of human rights. It's a type of human rights discourse. It's about, you have opportunity rights and then you have process rights, and this is about the sort of opportunity rights. And to me, human rights accord to all people. They accord to children. Children have human rights. Lesbian and gay and transsexual and bisexual people all have rights. And it's up to communities to decide how those are protected, but the expectation would be that we respect all humans equally. And we remember a time when children didn't have rights. Children's rights is a relatively new concept. We're talking 30 years perhaps. And we've only had a convention on children's rights since the 80s, and we still have so much work to do in order to support and enable and recognize children's rights. But it's a journey that we need to go on. Women didn't have rights less than 100 years ago in the United Kingdom. We have to engage and recognize that all humans have rights.
Okay. Unfortunately, we don't have any more time to do the second session. I'm afraid I have to finish the session. Ladies and gentlemen, finally we are come into our last agenda. We would like to say thank you again for Professor Thompson. Big applause to him. And all of the audience for the active participation. One thing that I read it on here, that is the, what is it called? The interest of the children, the best interest of the children are the most important thing. That's one that we have to keep in mind. Okay? Hopefully the presentation will give benefit for us, and thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much. And please for Mr. Bapak Toyibi for to give the souvenir for Bapak Michael Thompson. Thank you. Okay, ladies and gentlemen, for your information, so UMS provides a bus for the participant who stay in Lor-In and Lor-In Syariah Hotel only. Lor-In and Lor-In Syariah Hotel only. So this is a free service, bus service for free. So it's time for the parallel session 1 and 2. Which were located in the provided classroom. So thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.